Good afternoon and welcome to Covered and the Law. I'm your host Samson Ladi Anyanini. Covered and the Law. This is your legal light. It's your help law in these times. And as you know, we have spent 2 episodes looking at medical negligence. Today, we have the Medical and Dental Council here to help us with how they go through complaints of medical malpractice. What can you expect if you took your case to the Dental and Medical Council, Medical and Dental Council? Again, we will find out what has been the court's attitude if you took up a suit in determining what amount of compensation is enough for injuries suffered as a result of medical negligence or even death suffered as a result. Don't go anywhere. We'll be right back. Right, so let's begin on this note. Today we play back 2 cases of alleged medical negligence that happened in February and July. 37 Military Hospital and the Greater Accra Regional Hospital were cited in these cases as playing roles that led to the death of 2 individuals. Families of victims indicated following up the matter till its logical conclusion. Now, here is our news round for today.
On 24th February 2020, just few weeks to a COVID-19 partial lockdown, Emmanuel Asari Kuma accused the 37 Military Hospital of medical negligence. According to him, his brother, Solomon Asari Kuma, died while undergoing a brain tumor surgery there.
I took my brother to the surgical theater and administered oxygen, anesthesia, everything as if he was going to do the surgery. Then after a couple of hours, he brought him back. He said the equipment were not working and he would have to purchase a drill from South Africa.
Mr. Kuma says things spiraled out of control when some surgical equipment being used for the surgery broke down, and the events that ensued led to his brother's death.
Now, my brother was sent to the theater again. This time around, his head was cut open. It was probably 6-7 hours of surgery. I mean, it was a full surgery, and he said while it was used, the drill stopped working. So he had to suture his head. And that was when, I couldn't handle it. He sutured his head back. And throughout that process, when he went back to the ward, my sister noticed his leg swelling. So he did, alert the nurses' attention to this, only to find out that he had DVT.
In July, the director of Ghana Institute of Languages, Emmanuel Kutu, also sued the Greater Accra Regional Hospital, RIG, of killing his wife while on admission there on June 25th. He recounts events to JoyNews' Maxwell Agbagba.
She was totally in a mess, and she was in extreme pain. So I asked her, what happened? Have you been sent to? She said, no, the doctor hadn't come yet, but the nurses had come to administer medication to her, and then after that, she really wasn't well. I was there until the doctor came, a young man who came, and he came and went through the folder at the bedpost there, and then she asked the nurse what medication had been given, and so at a certain point, he said he didn't prescribe one of those medications. He didn't prescribe them. So there was, as I said, there was a kind of back and forth, and then a second nurse came and said, "Oh no, somebody else." They mentioned somebody's name who obviously I didn't know. Somebody else has prescribed that medication.
What becomes of these cases and how is help getting to victims who go through medical negligence.
This is COVID and the law, your health law and legal light. Now, our guests are ready to help us. Today, we are focusing on sanctioning medical malpractice. Sanctioning medical malpractice. You're aware that we have done 2 episodes on medical negligence and taking you through all you need to know and the education on what constitutes negligence as far as the medical practice or healthcare is concerned. Now, we have Dr. Divine Indobi Bayolibala, who is Acting Registrar, Medical and the Dental Council. Thank you for making time to join us, sir.
Thank you very much
for
inviting me.
Great. Also joining us via Zoom is Nick Papo Samoado, who is Managing Partner, Ado Legal Attorneys. Thank you, Ni, for making the time to join us.
It's a pleasure. It's a pleasure, Samson.
Great. As you are aware, we will spend some time to get back somewhat, piggyback on what we have done already on medical negligence, the errors that medical practitioners or health institutions commit, as a result of which you suffer some injury or may even suffer death. And then on the back of that, we find out the attitude of our court, supposing you had to take up a case of medical negligence in the court. But our focus today is on sanctioning medical malpractice. When a health facility or a practitioner does something wrong. Medical malpractice, as we understand, occurs when a healthcare professional or healthcare provider neglects to provide the appropriate treatment, or they omit to take an appropriate action, or to give you a substandard treatment that causes harm, causes injury, or could even cause the death of the patient. That is what is known as medical malpractice. And often, medical malpractice or negligence will involve a medical error. When it happens, apart from the opportunity of going to court, there is a place where you can seek some attention, and that will be the Medical and Dental Council. So the registrar is here. Now, Doc, take us through, first of all, what at your institution you consider as matters that patients or relatives of patients can bring to your attention.
Thank you very much. Samson, I saw, just before the program started, I saw the 2 cases that you dealt with. And anytime that we have a complaint of this nature, any complaint of this nature, is a clarion call to duty, because our primary public obligation is to ensure that through the infrastructure of professional regulation, as part of the quality assurance measures to guarantee patient safety and reduce harm, we act to be able to guide our professionals in a manner that leads to better protection for all of us. And remember, as a public interest regulator, and as for that matter, as the lead professional regulator in the healthcare sector, we are all brutally aware that all of us are potential patients. And therefore, professional regulation is our matter, it's your matter, and it is our collective duty, because in the end, the common value, the common interest of the people is what we look at.
Okay.
Now, I'm not going to be able to make any comments on those matters, and I will presently, you will understand why. But generally, when our primary object is to secure in the public interest the training, the highest standards in the training and practice of medicine and dentistry. Because of that, our regulatory mandate limits us to regulate medical doctors, dental surgeons, and a group of middle-level healthcare professionals we refer to as physician assistants. Now, to be able to achieve that, we have a number of systems to assure that's the first level of regulation, to ensure that those who meet the training standards and the practice standards are those who enter our registers. Because of that, we have a system of exhibiting every year in a gazette that register of the names of all persons who have attained the competency level that are appropriate in the professional respect and therefore are fit to practice for that year.
Okay. So these people you put in the gazette, the gazette simply is the public notice that legally the government, through the government or the state, the notice that is brought to you in a way that informs you that this is what is approved by the state. So you're saying that every year you put out that notice.
Absolutely.
In the gazette.
31st of January every year is by law
of
required.
All the persons, physicians, and those you have control of who have the requisite standard of training.
Absolutely.
Okay. You put it there for what purpose?
So that is one way of protecting the public, so that you know that it is persons who are listed here who are duly licensed as having attained the minimum competencies that will allow them to safely practice in this country called Ghana.
Okay.
In the various disciplines.
So you have an expectation that members of the public who are potential patients, like you said,
absolutely,
will check from the gazette, and when a doctor is attending to them, or a physician or health practitioner or dentist is attending to them, they will verify to be sure that that person is on the gazette.
Absolutely.
That's a difficult one.
That is actually standard international best regulatory practice. Samson, you are a legal practitioner. The only way I can know that you are so qualified is to look at the General Legal Council duly licensed practitioners for that year.
When you are looking for a lawyer, you may take a bit of time, but when you need care, sometimes it's an emergency situation. So you may actually not be conscious while you are being taken care of.
Absolutely.
Right.
I'm just talking about systems provided to limit harm, whether intentional or unintentional, on the part of practitioners. Okay. And as a professional regulator, that is our obligation.
Right.
The next level of it.
But putting it in the gazette, you know, we have a population with a lot of illiterates and so on. And even those who are literate, how would they even know that there is a certain gazette which is published every year that I'm supposed to look to confirm that a doctor who will attend to me is fit or is qualified to do so? I'm a lawyer. What they do every year is that when I renew my license, they publish it in the graphic, at least. That's a lot more publication than putting it in the gazette, right?
Yes. Thank you very much, Samson. But that is what the law requires of us.
Okay.
And as I say, even if you publish it in the graphic, for where I come from, it may take a month before the graphic reaches there. Okay. And even if it does, maybe not all of us, maybe most of them will not even be able to read. So, but that does not mean that publishing it is not a good thing.
No, but when you put it in the gazette, until I have the awareness to go to the government press to buy a copy of the gazette, I may never get to know.
I was just trying to explain to you the multi-layer, strategies provided to ensure that harm reduction is all targeted at protecting the public.
Okay.
So one way is to do that. That's the first standard.
Thank you.
It's only
what's the next level?
The next level is for us to have a system to ensure that you don't only just indicate that you have met, but you continue to retain that. So we have a continuing professional development policy which requires that you provide minimum number of credit points in various areas, including what we call continuing medical education, in addition to the continuing professional development. So, which means that if I were a surgeon, you need to acquire certain minimum number of credits in clinical work in the area of surgery. Then you can do other things, which will overall improve your performance. Now, as a professional regulator, there are 3 key things that we are interested in. And we are dealing with the very first, which is the technical competence of all your practitioners. And that is the processes that will show that you are the one technically competent. You must be on the register.
Right.
And then meet the requirements to maintain your name on the register.
So if you came to my office as a lawyer, I have my renewed license. I have it hanged in my office. You can inspect it and you will know that I am qualified. Even if you haven't read the papers to see it, you know that I'm qualified to provide you professional service for the year. The Ghana Bar Association also has introduced what is known as the lawyer locator. You can locate through just by, internet, Googling or going into a web page and finding out which lawyer is qualified. Or a lawyer tells you they are qualified, just put their name in to check if they are there. Am I able to go to a health center and determine that that center, first of all, is qualified, is competent, and then the practitioners are competent to take care of me?
Okay. Thank you very much, Samson. And thanks for the opportunity to further clarify. So you mix 2 things. You mix a healthcare facility with a professional.
That's right.
I'm a professional regulator. In our architecture, I told you that professional regulation is part of a wider infrastructure to ensure we quality assure the safety of all of us who are potential patients.
Right.
And so it is the health institutions, regulatory agency, HIFRA, which is responsible for whether or not a facility is in good stead.
Right.
But it is our responsibility to indicate whether if you hold yourself as a medical doctor or a dentist or a physician assistant, whether you are properly qualified to do so.
Okay.
And as I indicate, if you activate our system anywhere you go, you get any name you see.
Okay.
And I'll come down to that.
Which system is that?
So our website, if you hit it now, all the list of qualified practitioners.
You mean the
Medical and Dental
Council website?
Okay, we have it.
Okay.
The second level is that we have introduced a policy which we call stamp policy and name tag policy. And that is to address part of the issues. And I'll show you that it's slightly different from the legal regulation, which, profession which you both of us belong to. The difficulty here is that, and you identified, you engage the healthcare system at the household level. You don't engage the lawyer at the household level. And therefore, you have to have a system that takes accounts of that. So we have in this country where you can go to any pharmacy or any backyard facility, like you said, and then I will pretend that I'm a doctor, and then I just issue prescriptions. You have no way of telling at that moment. Now, what we have done is you are required to have a name, your name, together with your registration number. And that comes with a color coding, because we have 3 categories of registers for professionals regulated by us. And if you are on the permanent register, the color is different from a provisional register and from the temporary register for practitioners who are foreign and wish to come and do.
Since you are giving us this education so that we can help protect ourselves, assure ourselves of the quality of, care we get, of the care we get from whichever personnel. Can you indicate to us the color coding you're talking about, everything, so that when we see one, we know what we are seeing? So
the permanent register is green. The provisional register is pink. And then the temporary register is yellow. So this is the color coding. And so this is a new policy that we have brought on. The second policy has to do with the stamp policy, which we will be launching shortly. And the essence there is to ensure that we are able to trace every particular report or, for example, excuse duty, medication, laboratory requests to a particular practitioner. And that must have your unique identification number traceable to you. The next level is that we have quality assurance systems where we do monitoring to check. So just between August and now, we have undertaken monitoring exercises, sometimes purposive, sometimes routine, to gather information, go into institutions and verify the credentials of those who are there. Right. It led to the arrest of quack practitioners in a teaching hospital in Tamale. Not the Tamale Teaching Hospital, but the Tamale Technical University Hospital. We arrested another one in Medina, new site, I think. We arrested only 2 days ago, another one in Western region. Right. And currently, as I say, the team is somewhere I'm not be able to disclose.
That's fine.
And these are some of the measures that we have.
The question I actually asked you to begin with was, number one, what do you consider and expect to receive from your clients, so to speak, from the public, to constitute what you will look at in the way of a complaint to deal with a practitioner who has done a wrong thing? So you do that very quickly with me, then I go to Nipapo Samuado and we'll look at one
so
other
anything
issue
that touches on the competence of the service you have received.
Okay.
2, anything that touches on the conduct. It may not be the technical competence, but if the way the practitioner behaved does not reflect, and that is one of the values of professions, that you have established professional norms and conduct. Then the third thing is, if it is you think it's a violation of professional ethics. So these 3 things will lead you to us. And we are always there to assist and to listen to the story. Now, this information may come to us 2 ways. That you have actually identified that it is divine who attended to you and said this, or maybe didn't do that, and you felt that the care was not right. Then you file a complaint. But you, like, for the very reasons we just discussed, you may not be able to tell that it is divine. But you know that it is a practitioner who looks, light-skinned, and I met him here. That comes as information. Now, when it comes as information, I just want to put on record that the 2 cases that you preceded actually came to us as information. And I'll not be able to mention, but one of your sister media stations that broke the story of the sad case of Asarikuma, we contacted the production team, got information, and they took our own investigations. That led us to have the contact of the family, met with them, and then based upon the conversations and the discussions we had, then they filed a complaint before us, and that complaint is properly seized with us, and I'm not able to make any further comment on that.
Okay.
For obvious reasons. The second one also came as information. We followed up. I had personal meeting with Dr. Ruto, and he elected not to file a complaint with us. But we could have still gone on. We didn't have sufficient information for the case to proceed, and that is for that reason this case has not been moved forward.
We'll get to some of that, but as we know formally, the things that can constitute medical malpractice, for which, like Dr. Divine said, you may seek their attention or complaint. For example, if a surgeon, like he spoke to you about how many credit hours he are supposed to do, if a surgeon was taking care of you, occasionally some of them may make a mistake in the operating room. So if you are in a position of having been able to confirm that there's a mistake made in the operation, as in the surgeon, the surgery that was done on you. Sometimes it could be a question of some delay that occurred, something should have happened faster, it didn't happen, and then it led to some injury, some harm, or even led to death. That might constitute malpractice. And remember that in the last 2 episodes that we did, Dr. Justice Yangson and Dr. Ernest Dapa took us through some of these things, like anesthesia errors. Some of these, we understand, are mistakes that are frequently made, and they can be very dangerous, even than surgery mistake. A small error by the anesthesiologist can result in permanent injury, brain damage, or death. And a typical cause of malpractice by anesthesiologists include failing to investigate the patient's medical history for possible complications, or failing to inform the patient of necessary preoperative procedures. Remember, Dr. Ernest Dapa took us through all of that. There's also medication errors. Medication errors, one of the most common forms of medical malpractice, and can occur in many ways. For example, a doctor might make a mistake on the initial prescription, administer a drug inappropriately, or fail to take notice of potentially harmful drug, interaction. This can also happen. You could also have what is known as childbirth injuries. We've heard some stories about that in this country. Childbirth injuries. Some of these can lead to brain injuries, cerebral palsy, seizure disorders, fractured bones, full or partial paralysis, among others. And there's another one which we are familiar with, misdiagnosis. Misdiagnosis. There could be a missed or delayed diagnosis, which can cause malpractice. And so when you have situations like that, you make a complaint and they'll deal with it. We'll come to the procedure and see how much help you can get in that regard. But let's go to Ni Papo Samoa Ado. Ni, thank you once again for making the time to join us. Now, in looking at the subject of medical negligence and all the education we have received, we have been told that the hospitals or the professionals, they owe us a duty of care, and they owe us a duty to give us the best standard of care. Once they fall short of giving us that kind of care, and we can trace that they are the reason for some injury or damage that we have suffered, then we can take an action. What is normally the attitude of the courts, and you have done a number of these cases, in determining how much a person can get as a result of what they have suffered through medical malpractice or medical negligence?
Right. So I think you have covered a lot of based on what's proven and all that. So I wouldn't waste too much time there. But to necessarily start with, even though it may have been covered before, is the fact that because we are a common law country, we take our precedents or our cases from case law and from UK. Generally, the issue of negligence, proven as you know, is by preponderance of probabilities. To mean that you must necessarily bring enough evidence so that basically on the face of it, the court should be able to come to a conclusion that the 3 elements that must have been proven, that the duty of care, breach of that duty, and having suffered of that breach has been established. Just to go over quickly, duty of care being that there is not a factual issue as to whether or not a doctor or a medical practitioner, for that matter, may have breached a duty within our legal setting. That relationship as one in which there must necessarily be a duty owed the patient by the doctor. And so precedent is always a guide that in such a given set of circumstances, that is, if, for example, you went to a hospital and you were treated in a hospital, there has been decided cases where the standard of care that you must obtain or has been administered has been decided. So there is a place that as between a patient and a doctor, there is a duty of care owed by that doctor to ensure that the standard of care that is given to the patient is one that is generally the confines of what is to be expected of the professional. Then beyond that would be the issue of the breach, that having established the fact that, yes, when I walk into a hospital to be given a certain standard of care, as the practitioner, that is the medical practitioner, within the standard of the medical profession, has he breached any standard or the general standard that is expected? And there's a distinction that is often made between the levels of medical knowledge, as between somebody like a consultant and a general practitioner, for example.
Right.
It is not. You cannot expect a houseman, for example, to be judged on the same level as a consultant, for example, and there are case law to that. So the distinctions are even made in terms of the level of experience and expertise that is expected. Distinctions are even made as between house officers, for example, who are under the control and direction of a consultant, for example, as opposed to what would have been expected to do. So a student doctor or a doctor in training, a doctor who is yet to get to the level of a consultant, for example, and who is under the instruction of a consultant in an operating setting, standards applicable to him, as opposed to the consultant who has had a number of years experience, or a specialist or a physician who is expected to have extra skills based on the number of years of practice that he or she has had. Then you come to the issue of damage, that the injury that is suffered must be directly attributable to the breach that has occurred. The courts have been very reluctant generally to apply the principle of res ipsa, because most of the times that in the absence of having to prove the general duty of care and the breach of that duty, there are circumstances in negligence where the man was so the onus will now shift from the plaintiff to prove that the defendant had been negligent, and rather the duty will shift to the medical person to prove that in the given circumstances, even as you look at the facts as they are, you should be able to prove as the defendant that negligent. So shifted from the plaintiff to the defendant. That is generally not applicable in because most of the time what you are dealing with is within and just not on the surface of it. So it's more difficult to just walk into court and say that, my lord, I want to plead the principle of res ipsa.
Okay, so
you need to lead evidence.
Yeah, so we on this show, yes, we treated a number of the Ghanaian cases, and one of the very popular ones,
exactly,
where the court used the principle of the res ipsa, which means that you, the one bringing the case, we don't expect you to bring any evidence again. Let the one, the hospital, and in this case it was the Konfanochi Teaching Hospital, to prove that they have not done what they are led to have done. This was someone who had gone to the hospital to deliver and left the hospital with a part of the body off. So the question was, I came to deliver. How is it that?
Cut it off, yes.
How is it that I'm going back home? You know, without a limb.
Yeah. So generally, they may not. You see, there are certain instances that are clear cut. For example, if I go to a dentist and he ends up with my eye off, you clearly would not. The dentist had any business attending to my eye, when he was supposed to just deal with my teeth, for example. So aside clear-cut cases, the literature is generally that the court are generally reluctant, except when you have to leave evidence. So as a plaintiff, you must be informed so that you gather the evidence. The reason why I say this is a lot of times when we meet with clients who come with a complaint, I went to them, I heard this and I saw this, but when you ask that, okay, where is even maybe the prescription? Where is the report? Where is a situation where a lot of patients go to these hospitals and basically refuse to even take, prescription. We buy medicines. You don't keep. We have a general situation where a lot of patients don't keep documentation.
I need to bring you. I need to bring you in here on the fact that because of the previous episodes that we did, we took care of almost all these areas. So everybody who has followed this show and remembers properly would know what constitutes the negligence that they can go to court. They will know that the basic principle is that if you wait until after 3 years, you may not be attended to anymore. The time limit is for 3 years. You must come within 3 years to make the complaint in court. Otherwise, you have lost it. Just like if somebody owes you a debt and within 6 years you don't go ask for it, forget it, it's lost forever. We have told them all of those things. Now, the part we want you to help us with is that we heard some of our audiences talk about reading cases abroad where they hear that somebody has been giving $2 million, $3 million, and so on and so forth. How does it happen where we are?
Right.
How is the quantum determined?
Okay, so that quantum determined is based generally on what you have suffered as a party. Cases that are dealt with hospitals and the individual. Remember that the hospital itself can be liable for damages in respect of what injuries the person has suffered. Now, the plaintiff must necessarily give the court enough information for the court to be guided. For example, how old you are, what work you are doing, what incomes you were earning. When you have unascertainable income, the court will try to use general methods to be able to prove. But when you are a professional, for example, like Samson, you being a lawyer, God forbid if you have an injury and you can claim medical negligence, it might be easier for the court, for example, to ascertain your level of income, your level of profession, and then extrapolate it against the number of years that you would have. This is a death situation. For example, if it's a death situation, the court will look at the expected life expectancy in Ghana vis-a-vis when you died and what income you were earning, work around the inflationary issue, and make a determination as to how much it is that you have been an award appropriate to what you have been earning, and looking at also your dependents.
Exactly.
The fact that you have dependents and persons that rely on you. So the figures from the especially example, if you're a child and you suffer a life-changing injury, that is maybe there was an unfortunate case where you have a child operated upon and maybe his testicles or his his leg or some part of his body which has a life-changing characteristic and which can affect his whole quality of life for the rest of his life. Then the sums tend to go up.
All right.
The courts are very ready to make awards.
All right.
Most of the.
All right. Thank you, Ni. Unfortunately, Ni's lines too is not the best for us. I don't know why. Maybe because there's been a lot of rains today. It's affecting the internet connection. Yeah. So, I mean, if you missed anything from Ni's presentation, the summary is that the court will look at, for example, how old are you and the injury you have suffered. Maybe you have lost your legs, you can't walk again, you can't even work anymore. So how old are you? How many years were you potentially going to work for? What work have you been doing? How much do you earn? Who are your dependents? So if you can't work again, then it may determine that you need something that will make you mobile. Then how much will that cost? There are situations where people get some, clearly spec-made vehicles that will help them to be mobile again. And because they can't work again, they look at the whole period, how much you would have earned, calculate how much interest would have come on it, who are your dependents, who needs to take care of you, what do you need to buy to take care of yourself within all the period. So everything sort of put together, and then you are taken care of in that regard. Now, Doc, let's come back to your place.
Proceed.
The question I had asked Dr. Jesse Yangson the other time was whether or not, when a complaint is brought to your end, are you able to determine some compensation, or all you do is to discipline or sanction the individual involved?
Thank you very much, Samson. I will answer the question, but let me just clarify a few things in your earlier submission. People who want to complain to us need not be able to establish that something has in fact gone wrong.
Okay.
Because we recognize this is a highly specialized area.
That's right.
All you need to do is feel dissatisfied or have a suspicion that not everything went well. The second,
so you either you have a dissatisfaction or you have a suspicion, or both.
Like I said, on those three things, in terms of the competence of the care, or the conduct of the practitioner, or the ethics of the practice.
You just can't make the complaint. And allow the process to determine it. Okay.
Because as a quasi-judicial body, we are a fact finder, and therefore, because it's highly specialized, we are properly seized to be able to technically now peel the layers and be able to either affirm or deny the claim. The second point, which is a small point of law but very significant, is that just as careless conduct does not necessarily constitute negligence.
That's right.
So does misdiagnosis. Misdiagnosis simpliciter does not constitute negligence unless it evinces a failure of professional competence. And this I teach my postgraduates all the time. This is very important because sometimes the people can misunderstand it. So the mere fact that I've made a claim that there's negligence is purely a question of law.
That's right.
And that is why, before I leave this program, I hope I'll have time to make that point. That if it is about the protection of the patient, reducing harm to all of us, then negligence as a system is not the most effective of reducing harm, because of the nature of the contestations when you are litigating in our court, because it's an adversarial system, and therefore parties will now be more happy to conclude. But like you said, once somebody makes a complaint to us, we have two-tier system. The first system is we call it the penal cases committee level, is to now examine the facts, look at the complaint, relevant information. If we don't have enough, we will use our regulatory authority to access those records, put them together, and put this information before the first level of the disciplinary process, called the penal cases committee. Then the committee's duty at that point is to evaluate the evidence before it. And then when it is satisfied, based upon the information before it, determine whether or not a prima facie case has been made, and therefore whether this practitioner has a case to answer. That is all. Once that committee determines that the practitioner indeed has a case to answer, then the case is then referred to the disciplinary committee, where we conduct a full disciplinary inquiry. And all of these processes are underpinned by strict legal requirements. And therefore,
so you see the point you're making. one of the points Nee sought to refer to is that people could see a lawyer and they are narrating their incidents, but when you ask them the evidence, they barely have the evidence.
Exactly.
He talks prescription. They don't even remember where they threw it, you know, and all sorts of things. They have barely nothing. So it becomes very difficult for the one who is making the complaint to prove their case. How do you assess them in that direction?
Absolutely. And that is why we are there. You see, that is why the first point of call for anybody who is satisfied with a professional's thing should be the professional regulator.
Okay.
You may make a complaint if you are not happy with the way you were treated to the administrative body.
Okay.
Whether it is the chief executive officer or to the, if it's a Ghana Health Service facility, maybe to the director general or to the minister, but that's purely administrative. But once you make a complaint to the professional regulator, we are able to assess. In fact, some points when they come and say, and we have had that so many cases, we even assist you to write your complaint if you are not lettered. Any of our offices, we have a zonal office in Tamale, we have a zonal office in Kumasi, with the headquarters is in Accra, and only Thursday we have I sent a team. We are opening from tomorrow a zonal office to serve in Takoradi, to serve the secondary Takoradi areas. So once you come in, we will listen to your story and then we'll reduce it in accordance with the rules. Then we have the power to send technical people. In fact, we can call for your folder, the theater notes, the nursing notes, everything. And it is for the committee now, which are made up of lay persons, legal persons, and peers, to be able to evaluate and that is the beauty of our committee, because it constitutes members of ordinary people plus professionals.
People have a certain perception that you may be likely to protect the health professional and therefore will not do justice to them. What do you say to that? And I'll bring you, there's a petition that is seeking to organize signatures to ask for some sanctions against a particular doctor for having allegedly acted negligently, leading to the death of a media person. There's a lady who is known by the name Owuswa popularly. So it's already, there's a petition going around to collect signatures. And when it was put up, I suggested to those around it that I think you should take this to the Medical and Dental Council rather than on social media and gathering signatures, because it is not the case that you have gone and they have not acted and now you're looking to pressurize, to bring pressure to bear. And I get the answer, look, we are not in normal times and we know how sometimes they would like to favor the professional than the people.
Thank you very much. I'm happy for the opportunity. And every time I get asked the same question, and that is just suspicion, institutional suspicion, that one of our duties as professional regulators is to build confidence and trust of the public in the profession and it's the care that they get. That is important. In fact, if a complaint is made, the reason why we go through all this meticulously, we have to even move people to investigate and bring experts to look at it, is because once I bring the doctor before the disciplinary committee, it is now our case. It is not, you are just a witness, you the complainant.
I see.
Yes. So we have much more interest in making sure that we don't get, dismissed at the level of the committee as not having done a poor job.
Okay.
So it is, the person becomes only a witness. It becomes the Medical and Dental Council against the practitioner.
It's like when the state is prosecuting a case against somebody, a criminal case.
Exactly. So that is the fundamental thing. So nobody should have any qualms. And indeed, colleagues who are lawyers who have actually come with practitioners and assess our process have always attested to how fair. Unfortunately for us, we are dealing with rules that were enacted in 1975. And therefore, there's a lot of inherent delay, but that is a creation
of the law. The issue of inherent delay brings me to this point. Let me do this quickly. The procedure.
Yes.
You say people can bring the complaints.
Yes, please.
And even if they cannot write,
we will help them.
Once they come to you, you will assist them to do it.
Yes.
So they don't need a lawyer to help them.
They don't need a lawyer.
Right.
If they have one, great.
Good.
But they don't need a lawyer.
Right.
Because the Medical and Dental Council, on the disciplinary committee and the penal cases, we have lawyers. In fact, Attorney General is represented.
Okay.
The second thing is that as a council, because we are going to prosecute doctors, we also have a law firm as our counsel.
All right.
Who will be prosecuting the matter on behalf of the council before the disciplinary committee.
Right.
So it is a process they need not.
So they can only bring the petition to you or the complaint to you physically at your offices, or you have another way by means people can get to you.
So we encourage that they bring in the petitions, because sometimes when they bring in the petitions, and that is the next point I wanted to come to, because you asked the question that you asked Justice, whether we are capable of compensating.
Yes.
Unfortunately and regrettably, no.
Okay.
And that is...
So you only discipline the professional.
So we deal with the professional
But
discipline.
you don't determine that
the compensation.
You have suffered this much injury, so get much money.
Yes, actually we shouldn't be able to do that.
Okay.
We need a different system. And this is because it's my area.
So if someone is seeking compensation, then the only way out is for them to go to court.
Not only that.
But where?
They may go to court or go to Shraj.
Okay.
And Shraj does a good job at that as well. Because the court it has these inherent delays. And then the outcome, success rate is just 5% worldwide.
Okay.
In 95% of all the cases will not succeed. Only 5.
Okay.
Will go.
So imagine, let's take for example that in this case of Nana Mawusu Asa-82 that I'm talking about, who is popularly known as Owusua. If her relatives, unfortunately she's passed, if her relatives decided to take up the case, they will bring a petition to you. When they bring the petition to you, what is the procedure? What is followed?
Okay. So first thing is that our deepest sympathies with the family and friends, and this is really tragic. But to also make the point that we have to recognize that there's a positive assumption inherent in, and it's human nature, that when you go to the hospital, things will go well. You will be seen well, you'll get well, get better, and go home. It doesn't always, we know that as a matter of fact, it doesn't always happen. Even when nobody has been negligent. And it is important to underscore that. Now, once a petition comes before us, like I said, the first thing is for us to ensure that it meets the procedural requirements as provided for by law. Once, for example, if you are working in the public sector, you don't need anything further than a complaint simpliciter. But if you are not a public officer, the rules require that you now attach a statutory declaration to your complaint before it will be properly before us. So, and this is another layer.
If I bring a complaint
and you are not a public officer,
okay,
then you will require a statutory declaration.
If I suffered an injury,
yes.
If I suffered harm,
yes.
Fortunately, I'm not dead, and
I'm
bringing a complaint.
Yeah, you are bringing it, yes.
Myself.
Yes.
I need to make a statutory declaration.
That is, and watch the rules. The disciplinary proceedings require that if you are a public officer, you can just make the complaint, and that is all. But if you are not a public officer, then you require a statutory declaration attaching your complaint. Okay. Before it will be properly before us.
What is the statutory declaration supposed to say?
It's just supposed to affirm that this is not, a frivolous allegation. I just don't hate,
the
something.
doctor.
That is why I'm, and remember that once you engage our system, there are 3 outcomes.
So if I don't attach a statutory declaration, will you dismiss my petition?
You see, it can't go forward.
Okay.
The petition can't go forward.
Will you call me and tell me bring a statutory declaration?
We discussed that.
Okay.
Even when they have come with council, we tell council that, look, this is the situation. If there are instances where people come in and they don't have the means, if I have money on me, I cannot, but it is a requirement. If I don't have it, no matter how good your case is, I cannot, because a lawyer will come with a doctor and
but frankly, statutory declarations don't cost to do. They don't cost to do. So you get sometimes some of the commissioners can assist you, but more properly, a notary public will help you. They will draft it nicely, put your name there that you are so and so and so. This is your address, and that you are making this complaint. And like you said, all you need to show is that it's not a frivolous complaint, and that you are not hating or you are not against a particular doctor, but it's a clear case that has been made against you, and you are coming to them. And then they'll do it nicely for you, and then
we think this is an additional fetter on access.
So you want it
to the regulator. So we are pursuing amendments to Part 2 of the Health Professions Regulatory Body Act, together with the associated legislative instrument. And we hope that we'll be able to clean this out so that people can just come and complain.
How often have you had and found doctors or practitioners negligent or to have caused a malpractice?
So many times. Yes, and we have had the opportunity of the unfortunate situations where we have to actually strike people off. So as we speak now,
strike people off mean
completely
they can't practice medicine again.
Yeah, absolutely.
Or dentistry.
And as we speak now, we have 2 practitioners who we are fighting in the Court of Appeal, who are challenging our decision to stop them from practice.
All right.
The first level of sanction is a reprimand.
Okay, I'm sorry, but we have just run out of time, and we have had discussions in the background with Papoose Samoa. I'm sure that we can arrange to have him in the studio to look at this more clearly on the point of the law and the practical ways of going to court and getting something if this thing happens to you. So thank you very much, Papoose Samoa Ado, Managing Partner, Ado Legal Attorneys, and Dr. Divine Ndobi Banyolobala, who is Acting Registrar of the Medical and Dental Council. He has told you, it's very simple. Get your petition or complaint and bring it to them. Before I forget, tell us where you are.
So we are located at Ajabin Court premises, just next to the Cocoa House.
Right.
And we are open. And we have zonal offices.
Opposite Accra Police, Regional Police
Station.
Yeah.
Regional Police.
Thank you very much,